Good afternoon, and welcome to this afternoon's discussion on the new penal code. I'm sorry we are starting a few minutes late because of the very unprecedented VIP movement on Lodi Road, by which all common citizens like us have to suffer. So I think this is one of the fringe hazards of staying in the capital. There is something wrong with this mic. I can hear my own, I can hear the echo. Would you ask him to? So welcome to this session on navigating justice, analyzing the impact of the new penal codes on gender rights in our changing legal landscape. And this particular discussion, this afternoon's discussion, has been organized by the Guild of Service and the Justice Sunanda Bandare Foundation. And apart from the fact that the foundation and the guild work very closely together, there is an interesting intergenerational connect, because Justice Sunanda Bandare and Dr. Mohini Giri, the chairperson of the Guild of Service, and Justice Sunanda Bandare, on whose name the foundation has been started, both of them were colleagues and worked in tandem for gender rights. And it's very interesting that the next generation of women's rights activists, Manali, Singhal, and myself, Meera, Khanna, have now taken on the baton. The relay race is being run, albeit a little slowly, but it is being run, no doubt. So the next generation of gender rights activists have taken over. And of course, I must also mention that both Justice Sunanda Bandare and Dr. Mohini Giri felt that no matter how laudable the spirit of the law is and how good the law looks on paper, the ultimate litmus test is the applicability and the implementation of the law. That really decides how good or bad the law is. A very warm welcome to our eminent speakers, Justice Mukta Gupta, former judge of the Delhi High Court. Please give her a round of applause. And she was also the former public prosecutor for the government of National Capital Territory of Delhi. She has a very long list of achievements, and I'm going to leave that job to my colleague Manali. But may I ask Manali to give Justice Gupta a small token. Welcome. A very warm welcome to Rebecca, and also our heartfelt apologies to keep you waiting because of the difference. A very warm welcome to you, Manali. May I request you again, please? Welcome, Rebecca, and welcome, Justice Gupta. The Union government has introduced the three new penal codes, replacing the IPC, the CRPC, and the Indian Evidence Act. Of course, it has been replaced, albeit without any engaged discussion. So this particular discussion is to see what is the impact of these proposed laws on the work that gender rights organizations and individuals are doing. According to the government, the changes have been made underscoring the Indianness, the Indian Constitution, and the people of India, and the government intends to modernize the criminal justice system to keep pace with the changing times. And of course, it is vital in a country where legal recourse is the last resort due to the challenges in accessing rightful and timely justice. Quantitatively, the changes made by the three bills to the existing criminal code are limited. Almost, I think, of course, the eminent legal brains will correct me, but about 70 to 75% has been untouched. But qualitatively, are these new laws game changers, or are they just old wine in new bottles? There have been, when you go through the law, you feel it is there and yet not there. It is kind of what can I say, a road map has been created without any strategy on how to reach the destination. For example, the colonial overtones have been removed, particularly references to the monarchy and so on and so forth. But the colonial overtone is still retained in the fact that much of it is the citizens are under a cloud of suspicion, and it keeps them under the threat of arrest and detention like the old colonial laws. On the face of it, there are many changes, of course. The new laws prioritize laws that protect women and children, and for example, transgender has been included in the definition of gender, etc. But the crucial question for gender rights activists is, how do the new laws impact the advocacy and the grassroots work that is done by individuals and organizations functioning within the mandate of gender justice? For example, the BNS features stricter and wider ranging provisions for offenses against women and children. But the language and the tone of the revisions, however, betray a binary view of gender. And that holds fast to this rather antiquated notion that the women's honor is in need of preservation. So rather than treating women as equals, the binary still exists. So then the crucial question is, how do we navigate within the new laws to obliterate patriarchy and safeguard gender justice and equality? I'm looking forward to hearing these incredibly sharp legal minds in what promises to be a very engaging and illuminating discussion. I'd like to stop here with a favorite quote of mine by John Locke, which I feel is really the most important touchstone for democracy. I quote, "The end of law is not to abolish or restrain, but to preserve and enlarge freedom." So the moot question now is, how do the new penal codes perform on this touchstone? Once again, welcome to our eminent speakers and to this very august audience, and I turn the floor over to my colleague, Manali.
Hello everyone. Sorry, this morning I woke up with a sore throat. Welcome, of course, to our very, very esteemed speakers here today. I have been given this job of introducing both Justice Mukta Gupta and Rebecca, who I know need no introduction. Most of you know them, but they have been, in fact, they are trailblazers for women, because when they started practicing in the criminal side, there were very few women lawyers at that time in this field of law. And they really made a difference and made a mark and led the way and opened the gates for many other women to really enter this field. And now I think, Rebecca, there are quite a few women lawyers also who are practicing criminal law. But since I have been asked to, I'm just going to give you a little bit of an introduction on... You want to just start? Just 2 minutes. Huh? Okay. Anyway, everybody knows, and I think little bit Meera had also told them, and I'll just give the floor to them only so that they can take this forward. I know we all have gotten a little delayed because of everybody took a little time to come today. So Rebecca and Mukta, welcome, and thank you for accepting our invitation. If I could request Justice Mukta Gupta first to just give her thoughts on.
Good afternoon, everyone, and sorry for having kept you all waited. Unfortunately, on the road, every light was red, and I have always felt that law has three aspects. One is as defined by the legislature. The second is how interpreted by the court. And third is how executive implements it. A very well-meaning enactment can be most abused while implementing, and an insane legislature can also be very well implemented by the executive. At the same time, courts have often read down provisions which have no meaning or which meaning is not as per the constitutional goals. So ultimately, enactment is one thing, but what will come out from these new penal codes enactments is we'll all have yet to see. I'll give you a very small example of it, and it has both sides in it. Till now, there was a concept that if an offense is committed in a particular jurisdiction, that offense should be registered in that very jurisdiction and investigated and tried. Even if beyond that territorial jurisdiction that offense was registered, it was at best as a practice a zero FIR and transfer the zero FIR to the jurisdictional police who will investigate. This time, the BNSS, the procedural code, gives a very long arm in section 173. It says that supposing it's an offense committed in Delhi, the complainant can go to Uttar Pradesh and say, such an offense at Delhi was committed on me. On the permission by the DSP, a preliminary inquiry will be conducted and thereafter an FIR can be registered and investigation carried out. Which means for an offense of Delhi, which is typically a law and order problem of Delhi and a state circuit, an investigation can be carried out in another state, the person can be arrested, and all consequences to follow in that state. So, though a well-meaning provision, if you see the matrimonial cases, women have a lot of problem. They can't get the FIR registered at their matrimonial house, and most of the time they go back to their parental house and get the FIR registered. We've been always interpreting it that because the marriage took place at the parental home, entrustment was there, so the cause of action arises. What is beneficial in that scenario can be an abuse in another scenario. Now that is one thing which really affects when an enactment is required to be made and interpreted, because once it is in the common domain, one doesn't know how it is implemented. What is legal, fair for one can be badly abused by the other one. So this is here what we see in this new enactment. By and large old provisions, but there are certain provisions which have been tweaked, which have been slight tweaking has had ample effect. In fact, there are now 356 sections and 20 new offences have been incorporated and 19 provisions from the earlier IPC have been removed. And 33 offences they have extended the imprisonment and fines extended in 83 offences. There's a new chapter, chapter 5, which deals with offences against the women and child of sexual, women and child of sexual, of offences against women and child of sexual offences. Now, of course, most of the definitions, like section 74 of the BNS, is identical to section 354A as it stood earlier. But yes, a distinction which has been brought, that a minor and child distinction has been removed. It is all anybody who is below the age of 18. It's one level. Then for the first time, transgenders have been defined, and it's been included in these provisions. Then electronic and digital data, which were earlier by way of interpretations known as documents, have been formally defined as documents. Over the years, we've seen how movable properties have increased today. More than these tangible properties of money, goods, you have a lot of other properties like the IPR properties, software and all. So they have also been included. So anything which is not attached to the earth or can be permanently fastened to the earth, that will be a movable property. Now, there is one significant change, like if an offence is committed in India but the abatement took place outside India, that abatement itself also will be an offence and will be punishable in India, tried and punished in India. Now, this was in the wake of most of the terrorist activities which take place. The abatement takes place somewhere else, and then you are left high and dry, you are not able to take. Then section 69, I think a welcome section, which now defines a new offence, that is sexual intercourse by employing deceitful means. We all know and seen that sexual intercourse or the false promise of marriage, employment, promotion, etc. were there, and so they were all put in the category of rape earlier. Now they have been given a separate definition under section 69 of the Act. Then till now, whenever there was a mob violence, lynching, etc., we would fall back to our traditional offences like hurt, grievous hurt, culpable homicide, homicide not amounting to murder, attempt. Now there is a separate definition given of under section 103 with regarding issues like mob violence, murder or grievous hurt by 5 or more persons, which may include on the grounds of caste, community, place of birth, sex, race, personal belief, language, etc. Now there's a complete act has been incorporated in one section, that's section 111, 111. In fact, there is a Maharashtra Makoka Control of Organized Crimes Act, which was extended to Delhi. Then on similar lines is the G Koka, that's the Gujarat. Then Andhra Pradesh has it, AP Koka. So many of the states were having to deal with this organized crime. Now section 111 has completely incorporated that provision in that entire enactment into it. Now let's see, when we say one is enactment and the other is how abusive it could be and how well-meaning it can be. Let's just read that section and I'll just like to give some explanations to it. Section 111, organized crime. You know what organized crime was? If 2 or more charge sheets were filed against a person in the last 10 years, then it was held to be an organized crime. With that act, there was a schedule which offences would come as an organized crime, which included waging of war, narcotics, prostitution. Now they have all been included. With it includes economic offense. Now what do you mean by economic offense? Supposing 3 FIRs of forgery are registered against a person or 3 of cheating are registered, he becomes liable to this organized crimes. Then similarly, you have provision like this which can be very badly abused, may be meaningful also. What happens? There are 3 transactions. Supreme Court says each transaction is a separate offence. Supposing same complainant lodges 3 FIRs against you for 3 different transactions, where does one go? He'll be liable to come under this organized crime. So, enactment for a very laudable purpose can often lead you to a very serious consequences. Now, if you see this provision, what is economic offence? Includes criminal breach of trust, forgery, counterfeiting of currency notes, this is acceptable bank notes, government stamps, hawala transactions, mass marketing fraud, or running away with schemes to defraud several persons, or doing any act with a view to defraud any bank or financial institution. Now I think in business, most of the people take 2, 3, 4 loans and one default, where do you land up? As an organized crime. So there are a lot of pitfalls as well. Then defraud any bank or financial institution will be for obtaining monetary benefits in any kind. So this is why when I started I said one facet is enactment, defining by the legislature. The second aspect is how the courts interpret it, and third is how the executive implements it. Now there is yet another aspect of interpretation in this. Section 111 says organized crime, any continuing unlawful activity including, so the word uses including, kidnapping, robbery, vehicle theft, etc. Now including, Supreme Court has repeatedly said when the very enactment uses the word including, it means the definition is not exhaustive. So every other similar activity will fall into it. So we do not know which all activities will ultimately line up into it and be included in this provision. So very good enactment, but yes, maybe if somebody is up to a mischief, can really put people in trouble about it. Then there is one more addition in this, which is section 141, which is importation of a girl or a boy from a foreign country, where the girl is under 20 years and the boy is under 18 years and are forced to illicit intercourse with another person. Now this is to see that the trafficking, human trafficking is taken up seriously. We used to have theft, robbery and all. Now there is a new definition which has come, new offence which has come, which is snatching, which we loosely use. It's a new offence which has now been introduced in this, that's section 304 of the BNS, which now says and defines and criminalizes snatching, making it an offence throughout the country. So then there is the distinction between, with regard to the age, in the case of gang rape has already also been removed. I think now it is for everybody. That's yeah. Section 70 subsection 2 now mandates life imprisonment till the remainder of the life of the offender's natural life, and death penalty for the crime of gang rape committed against a woman below the age of 18 years. So the earlier offences of sexual overtones like voyeurism, disrobing, etc., they have been now made gender neutral. POXO was gender neutral, but when we had 354A and all, they were specific to the women. Now this is a gender neutral provision which has come. So even if a boy or a girl, any one of them is misbehaved in this fashion, they will be all treated equally. Now, one section 95 has been introduced which makes the act of hiring, employing or engaging a child to commit an offence a punishable offence. So if you hire a child to commit an offence, you are liable to be punished for the offence. This has come in the wake, I think of late all of you would have seen what used to happen. All these mafias, especially the drugs and all, they would take small little children who were, yes, juveniles, and then supply the drugs through them. With the result, if the child was caught also, it had to go to Juvenile Justice Board, inquiry, all those benefits had to go. So they would get scot free. So they have now said that if you employ a child for doing all this, you will be punished. This has been made a separate offence. Besides the act of abatement and all that, this is now a separate offence. So till now we had two definitions in the IPC of hurt, and that simple hurt and grievous hurt. There is now an amendment in sections 117, subsection 3 provides stringent punishment where the acts causing grievous leads to persistent vegetative state or permanent disability. Often it used to happen that the injury was such that the person would get into a vegetative state or be totally dependent for the life. I mean, his life is there, but totally meaningless life. The only provision again there was 326 or 307. So now a separate provision, and the punishment for this has been extended to rigorous imprisonment, which may not be less than 10 years, extendable to imprisonment for life, which could include remainder of the life. So it would depend on the gravity of the offence. Besides these changes in the IPC, there are some other changes which need consideration, because the manner in which an offence is investigated, tried also needs consideration. But before going to that, I would also like to tell you in this, what has happened is, till now, in most of the provisions of the IPC, the punishment was which may extend to 3 years, which may extend to 7 years, which may extend to 10 years, and oblique or the fine. Now this gave a wide power to the court to modulate the sentence as per the crime committed, the gravity of the crime, the circumstances of the person, the contribution of the victim into it. There was a lot of factors which weighed in the mind of the court, and somewhere, even if the offence was serious, but it had other considerations, so the court would give a light punishment. Now the tweaking which has happened is, in the IPC is, instead of up to extend, most of the provisions is which may be punished for a sentence of imprisonment for 3 years, for imprisonment of 7 years, for imprisonment of 10 years. So now there is no distinction left. I will just give you example. While sitting in the court, often it happens, and this, I think all of you would be able to relate to it. When these are offences of POXO or rape or even 354, there is a landlord-tenant dispute, or at times even inter-see the family dispute. Allegations are levelled against the uncles, cousins and all, or the tenants and all. Courts would look into the matter, and even if there was statement, every corroborative evidence, seeing that there was some element that it could be a case where there was some chances of manipulation, the court would tweak on the sentence aspect. That look, instead of 20 years, this was a young boy who had just passed out of the college. He's been into the custody for 10 years, 12 years. 10 years is a minimum. Let's leave him. Keeping the reformative approach in mind. Now, with this tweaking in the penal code, I think that discretion has just gone, and it will be very, very difficult. If there is an offence, irrespective of the circumstances, it's 3 years, 3 years. You have to undergo 7 years, 7 years, 10 years. So that discretion taking away will be a serious game changer in the IPC offences. Now, as far as the investigation aspect is concerned, there are some provisions which have been introduced, which are beneficial. Yes, of course, the zero FIR and investigation to be carried out in another state I've already illustrated. But there is one provision under section 145 of the BNSS which provides that the dependent father, mother, they can even file a complaint at their residence, and rather than going to the place where the son or the daughter is residing for the maintenance. Earlier they had to file a complaint at that place. So they get the relief, which is good. Now, there is, for some offences punishable less than 7 years, the concept of preliminary inquiry has been introduced, which I think has its own benefits as well as pitfalls. We all have seen often there are number of false complaints filed. Supposing there is a dispute between two neighbors, at the drop of the hat you will find the complaints pouring in, disputes between landlord, tenant or family. So those preliminary inquiries had the advantage that the police would say, nahi, ye to roz ka jhagda hai, kuch nahi hai, we just close it after preliminary inquiry. Now look at the consequence of this. If there was no, after Lalita Kumari's judgment came, police had no option but to register FIR. And see, with the introduction of section 111, as I said, 3 FIRs of that kind registered and you are an organized crime person who can be booked for organized. So if the police comes to a mischief, they can just ruin anything. This is a very very dangerous aspect which we'll have to consider in this. Now, this new CRPC also provides more protection to the victim and wanting transparency in the investigation relating to offences of rape. Thus, now the statement of the victim is required to be recorded through audio video means. What used to happen was earlier, since the police would record or the consular would record or thereafter the court would record, at times children say in a very unintelligible way, but the person who's recording puts his own word. Now, touch kiya, insert kiya, isi mein hi the offence becomes totally different. So now it will be audio video recorded so that the court can just look into what exactly the victim said. Then there is a provision that for any offence which is punishable with 7 years or more, you will get the forensic team at the site. Forensic analysis of the crime scene is a very, very important aspect because it leaves so many telltale signs which lead you in the right direction. So this is, and it is said where the forensic facility is not available, you will ensure, the state government will ensure that it is available, and in the meantime you will call from the neighboring state about this. And I am sure slowly every state now has those things and will strengthen up those aspects. Now, there is one more beneficial aspect. In serious and heinous offences, Section 183 now requires, for offences which entail punishment for imprisonment for 10 years or more, or life or with death, the magistrate is bound to record the statement which we used to call 164 statement, which was only for the rape victims. So what used to happen was, the police would say, the normal allegation was that police manipulated the statement, the witness was not even there. When it is recorded before the magistrate, there is some kind of assurance that yes, what the victim is saying is right. And then if it is a lady, preferably the statement will be recorded by a lady magistrate. If not, then by a male judicial magistrate in the presence of a woman. Now, there have been steps which have been provided for completing the investigation and in a rape case, that within 7 days the report of the victim or to the investigating officer should be given by the medical practitioner, supply of medical report, etc. Then checks have been also put on the police officers as while conducting search at a place in the case diary, and this has to be noted. And when the search is to be conducted, it shall be recorded through audio, video, electric means. Most often the problem used to be, they said it was recovered from this place, and the accused would contest that this was not the recovery made from this place. So this will be now audio video recorded, but I'll just give you one example how audio video recording can also be manipulated. So we were doing a trial where there was a kid, I was doing an appeal where the child was kidnapped and buried somewhere in UP. So when the police took all these accused, there they said it is at this place, so the digging had to be more. So they called the person, somebody with the favra and all, so that they could do the proper digging. Now obviously when this interregnum time when they call, it changed. They said, no, look, they pointed out here, the digging is being done here, because by that time from morning it was evening. So they said, this is not the same place. Then we said, look, this is the reason what has happened. Now, audio video recording has to be done with intelligence. If it is not done intelligently, it will actually ruin the entire case. Now, there was one aspect which was always troubling, that 15 days police custody at the best was available to the police. But often it would happen that the other accused was not arrested, so that 15 days custody, and that 15 days custody could be taken in the first 15 days only. So if the other accused is not arrested, they could not do it, and the confrontations did not take place. They said, you will get a total of 15 days, but you can do it in the first 40 to 60 days of detention. So you take PC remand for 5 days now, after 15 days you can again take. That will be that can even lead to serious abuses, because more the police custody, more excesses, and what consequences flow, we all know about it. Then the police officer is mandated to inform the complainant about the stage of investigation in this case. Then even checks have been placed on the judges that you have to pronounce the judgment within 30 days of conclusion of the arguments, and it may be extended to 45 days at the maximum. There are certain victim-centric amendments which have been brought in the Act. Victim has been given inclusion in the key decisions by the state, like if there is to be a withdrawal of prosecution under Section 360, the victim will have to be consulted. The concerns of the victim will have to be incorporated in this. Then a witness protection scheme has been mandated. One of the problems which is plaguing the Indian criminal justice system is the protection of the victim. We are never able to protect. We've seen in high profile cases also where the witnesses have round the clock police security, they turn hostile. Because presence of police does not mean the means to allure or threaten the witness have gone away. So each victim needs a different kind of protection which has to be seen. So there is a mandate now that witness protections will be afforded and schemes will be prepared in relation thereto. Now, with regard to the first time offenders, the provisions of the bail have been liberalized, that yes, then, but yes, if it is a repeat, it's now harsh. So these are some of the changes which have brought out. Most of them are very well meaning, but if a proper check is not maintained thereon, it can lead to disastrous consequences. Thank you very much.
May I request Rebecca John to...
When I look at these three acts, I have difficulty pronouncing their names even now.
The mic is
BNSS.
Yes, I think as a person who has always practiced criminal law, this is going to give me a world of pain. The entire placement of sections that we are familiar with for more than 100 years has changed. There has not been that much qualitative change in the section, but for example, the definitions chapter, what the new act of new penal code does is that it puts it all together under section 2. Earlier it extended from 2 to 30 odd sections. So there has been, since the placement has changed, a lot of what we say colloquially, 420 is no longer 420, 302 is no longer 302, everything has changed, and that would really, practically speaking, for those engaged with practicing criminal law, for those engaged with courts engaged with giving justice, this would mean a complete shift in their in the manner in which they address these provisions, and it would take us some time to get used to the new laws.
I'll just add over here. There'll be one more problem. There'll be some matters which will go under the old provision, and some which will go under the new provision.
Yeah.
So matter-wise, we'll keep shifting which section.
That's right. That's right. Depending on when the offence was committed. Therefore, I think I don't have any difficulty if the law the law has been amended. I think law must evolve over a period of time. But the manner in which this has been done, I definitely agree that this is old wine in new bottles. It's basically the same thing. There was a certain neatness in the old provisions, which is completely absent now. And I'll give you an example. For example, if you look at, say, a provision like 354, which is assault or criminal force to women with intent to outrage her modesty, it contains the definitions of two other provisions, assault or criminal force. Now, they precede 354, because 350 from 350 onwards, 350 is a definition of criminal force, 351 is a definition of assault, 352 is punishment for assault or criminal force, 353 is assault or criminal force to deter public servants, 354 is assault or criminal force to women with intent to outrage their modesty. So there is a structure there. Now you have assault, criminal force defined in one corner of the penal code, and you have assault or criminal force to women with intent to outrage or modesty in another place in the criminal code. And there's no correlation of these sections that will also add to the pain of practitioners. But largely, what these sections have done is amalgamate previous sections, and therefore the advantages of short titles to the earlier code is now completely missing. And you have these long sections which incorporate 4 or 5 other sections without breaking it down. And you have sub-provisions. And so therefore, even for the ordinary public to navigate through these provisions would be very, very difficult. They talk of replacing colonial law. I don't think this is an exercise which has done it. It has complicated the space in a manner that was completely unnecessary. With respect to offenses, particularly relating to women, as Justice Gupta said, what was 375, the definition of rape, is now 63 of the penal code. What was a single aggravated offense of gang rape in case of victims of rape under section 376DA and 376DB has now classified under one provision, and now the distinctions in age have gone completely. Those below 12 years, those below 16 years. It's now women or girls below 18 years. That's the only standard classification. I have a problem with the introduction of section 69 of the code, of the new penal code, which is this old promise to marry section. I'll just read out the definition. Whoever by deceitful means or by making promise to marry to a woman without any intention of fulfilling the same has sexual intercourse with her, such sexual intercourse, not amounting to the offense of rape, shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Now, deceitful mean has been defined in the explanation and shall include inducement for or false promise of employment or promotion or marrying by suppressing identity. If this is not about rape, if the section itself says that sexual intercourse not amounting to the offense of rape, and rape is predicated on consent, you are implicitly therefore arguing that this is not rape. This is nothing, there was consent. If there was consent and you're bringing in deceit, it's deceit for purposes of having sexual intercourse. I think it's a problematic section. It was problematic earlier. It is still problematic now because it denies agency. It somehow puts a premium on marriage. Well, the Uttarakhand Act does put a premium on marriage because it says that non-marital relationships have to be registered. And if not registered, it is a carceral of, it will lead to punishment. all of this, I think, denies agency to women, where you place marriage at a premium, and any and if the relationship sours, which it can happen, then you're not entitled to call it off, so to speak. And you've included things like employment, promotion, marrying by suppressing identity, very broad stroke definition, which can be misused, and then the burden of misuse will again fall on women. But then you have placed the offense in the penal code. I think it would be problematic because it also has a high punishment of 10 years. It is easier for courts to convict under this section rather than 375, where consent is a complicated definition and the ingredients to fulfill. Now, largely speaking, with respect to other sexual offenses, Justice Gupta is right. Some of them have been made gender neutral. For example, disrobing and voyeurism, the assailant can be man or woman. Other than that, even with respect to punishment for buying a child for purposes of prostitution, earlier it was a girl child, now it includes both male and female children. Procuration of minors and importation of minors from foreign countries, all of this has been made gender neutral. It includes the male as well as the female child, which is fine. The offenses against women have been placed under a separate chapter. I think it's a bit patronizing. Earlier it was offenses against the human body. I would prefer that. Why have a special provision, a special chapter dealing with offenses against women and child? Other than that, some of the important feminist interventions made in the past with relation to abortion has been completely disregarded. What was earlier 312 to 316 is now sections 88 onwards, where the provision seeks to penalize voluntary termination of a woman's pregnancy unless the abortion poses a threat to the woman's life. So those sections have been retained despite decades of feminist intervention asking for more agency to be given to a woman to decide whether she wants to terminate the pregnancy or not. Of course, these provisions have to be read in conjunction with the Medical Termination of Pregnancy Act. Despite the belief to the otherwise, adultery has been removed from the new penal code. I've had the advantage of seeing all the three drafts. In the initial draft, also adultery was not there, but the standing committee had recommended that adultery be brought back, and that was where the confusion arose. But in the final statute, adultery has been removed, giving credence to the Supreme Court decision in Joseph Shine. What is disturbing is the removal of section 377 of the Penal Code altogether. Now, if you recall, 377 was the subject matter of the Nas Foundation judgment of the Delhi High Court and later on the Navtej Johar judgment of the Supreme Court, where consensual same-sex relationships was decriminalized. But this doesn't mean that you cannot or will not punish non-consensual same-sex relationships. And by completely removing 377, I think a great disservice has been done. This in the light of the fact that Section 210 of the BNS introduces or includes, gives us a new definition of gender, which includes man, woman, and transgender persons. But when I went through the penal code, I find no parallel benefits to transgender persons, because rape can be accessed only by a woman. 377 has gone away. So by merely including that definition in at least sexual crimes, you are not giving trans persons or cisgender men any kind of protection. So that again is, and you will recall that the Transgender Persons Protection of Rights Act, which is many provisions are under challenge in the Supreme Court, it criminalizes sexual assault against trans persons, and the maximum punishment is 2 years. So I think we've done a great disservice for not recognizing, after including trans persons in the gender definition, for not giving them any parallel beneficial provisions. Other than that, there are certain new sections which have been introduced. For example, mob lynching, new offenses of mob lynching and grievous hurts on prohibited grounds. Now, as I said, 302 is no longer 302, it's 100 and 101. But in the punishment aspect, they have said, subsection 2 reads that when a group of 5 or more persons acting in concert commit murder on the grounds of race, caste, community, sex, place of birth, language, personal belief, or any other similar ground, each member of such group shall be punished with death or with imprisonment for life, and shall also be liable to fine. Now, firstly, there is no, it comes repeatedly throughout the penal code. What is the meaning of acting in concert? So we have the concept of common intention, you have the concept of conspiracy, and then you have the concept of unlawful assembly. But what is the meaning of acting in concert? This is a phrase which is repeatedly used throughout the penal code, but with no parallel definition. I actually don't understand the point of section 103(2) because it comes within the punishment chapter. It is, after all, murder, unless, of course, it is a social recognition that the murder was committed on grounds of race, caste, community, sex, place of birth, etc. But there are no parallel reliefs in terms of evidentiary standards. As you're all aware, when such like offenses are committed, very often it's difficult to get evidence. And if they really wanted to create this as a substrata or a different kind of a crime, I think there should have been parallel reliefs in terms of lowering evidentiary standards, which has not happened at all. So there is just a artificial imposition of this mob lynching definition in the punishment chapter without a parallel offense being made. Likewise, sedition, it was said with much fanfare, has been repealed under 124A, which was 124A of the IPC. It has come in an equally unintelligible form in 152 of the new code. So it exists in a different place, but basically with the same intent and with the same kind of punishments. The introduction of not just MACOCA, but also provisions of the UAPA, I think is deeply problematic. Now, at least with MACOCA, because MACOCA was particular to some states, it was a Maharashtra Act which was adopted by Delhi. There were similar acts in Gujarat, Uttar Pradesh, Telangana, Andhra Pradesh, etc. The question I have to ask then is, would MACOCA survive or would these provisions survive? Because if you have made it pan-India, is there going to be an overlap or one or the other is going to go away? At least with UAPA, where many offenses of UAPA have been incorporated in the new penal code, those provisions, with respect to those provisions, there is at least a clarification. In as much as the explanation to section 113 says that for the removal of doubts, it is hereby declared that the officer not below the rank of superintendent of police shall decide whether to register the case under this section or under the Unlawful Activities Prevention Act of 1967. So a superintendent of police has been given the power to decide whether the offense, which comes within the category of terrorist crimes, can be registered under the UAPA or whether it will be registered under the penal code or not. But there is no such parallel section when it comes to MACOCA. I don't know whether this is whether this is deliberate or whether this is an oversight. But as you are aware, section 21(4) of MACOCA and 43(d)(5) of UAPA places enormous restrictions on the right to bail. There are also other provisions where the period of investigation can be extended from 90 days to 180 days. Now, if they were to remain within the penal code, would the embargoes on bail and the completion of investigation within 90 days, not extendable to 180 days, remain? Or what will happen? As a criminal lawyer, I would argue that since there are no parallel embargoes on bail, that perhaps registering it under the penal code might be better. I hope nobody from the state is listening to me, because they might just bring in an amendment. Likewise, there are changes in bail provisions, some of which is good, not all of it is good. But what disturbs me most are the changes made to the what we used to call 167 of the Criminal Procedure Code, which is now 187 of the new Procedure Code. Earlier, a charge sheet. Earlier, a person arrested had to be produced before a magistrate within 24 hours, and the magistrate could remand that person in tranches of 15 days. It was made clear by the statute that only the first 15 days was interchangeable custody, and after that, you had to send the person to judicial custody. That has changed now. Because what this, and I have serious reservations and I have serious opposition to that change. It gives the police the power to stagger their police investigation for a period of 40 days, where the offense is punishable by 60 days, for a period of 60 days, where the offense is punishable by 90 days. As a practitioner, we always advised clients that let the first 15 days period be over before you apply for bail, because then the police custody argument will not be taken. What it now means is you have to wait for at least 40 or 60 days before you can make that application for bail, because the police can always turn around and say, we haven't completed our 15-day period. I think it's dangerous. Ultimately, laws have to keep in mind the mandate of Article 21 and the mandate of the Constitution. It should be pro-citizen. We cannot have laws which work against citizens. And I think because we are all familiar with misuse, this provision can be subjected to tremendous misuse. There's a bit of trivia which my colleague in office told me yesterday, but I found that funny. There's a second proviso to this provision, which says that when you talk of custody, permissible custody, then it's only police stations or jails. And he asked me this question, to which I had no answer, that if a person is arrested in Bangalore and brought by train from Bangalore to Delhi, what happens to that 2-day train journey? Because it's neither a police station nor a jail. As I said, it's trivia, but it may. So there is. The new provisions introduced have this looseness in drafting, which is very, very evident. Whatever you may say, colonial, not colonial, there was a tightness to the drafting which kept the acts together. It's now loose, and because it's loose, it is capable of all forms of interpretations. There is a section 172 which has been introduced, which again gives powers to the police. It says that all persons shall be bound to conform to the lawful directions of a police officer given in fulfillment of any of his duty under this chapter. A police officer may detain or remove any person resisting, refusing, ignoring, disregarding to conform to any direction given by him under subsection 1, and may either take such person before a magistrate or in petty cases release him as soon as possible within a period of 24 hours. What it means is that directions given by a police officer, violations of those directions have also been made culpable, and you might suffer custody up to 24 hours. I see some feminists sitting here who do dharnas at various places. Please be on guard. Then there are timelines given which. So there were always timelines. I saw many journalists were very excited about these timelines, and I said timelines have been followed in India through its breach and not otherwise. rape cases are supposed to have been to be concluded within a particular period of time, never done. So there are extended timelines. I don't know whether any of these timelines can be adhered to when you have a criminal justice system on the verge of collapse, if it hasn't collapsed already. Look at the number of cases every judge has to deal with. I'm talking about my own high court, where every judge on the criminal side is dealing with more than 100 cases every day. How do you expect them to adhere to timelines? Look at magisterial courts. Look at sessions courts. Now, it's wonderful to say that you must frame charges within 60 days from the first date of hearing. It is wonderful to say you must pronounce a judgment within 30 days. But when you parallelly don't do anything to improve the system in terms of infrastructure, in terms of the appointment of judicial officers, etc., courts don't have prosecutors for months on end. Are these timelines even realistic in a country? And the sheer volume that we deal with on a daily basis, I'm not sure whether these timelines can be adhered. It may be a good idea, but it may just remain as an idea and nothing beyond that. Community service has been introduced as a new punishment. In principle, I approve. Depends on where I'm asked to do community service. I might have an opinion on that subject. But otherwise, it may not be such a bad idea. Now, in your concept note, I noticed some errors. For example, you have stated that there's a new definition of cruelty. There is indeed a new definition of cruelty under Section 86. 498A is now Section 85. But Section 86, which is a so-called new definition of cruelty, is actually the explanation to Section 498A, which has now been carved out into a new section. So this happens throughout the Act. There's nothing new about it. It probably existed in another form in the previous Act, and it's still there. It comes up as a new this thing. Yes, marital rape has not been recognized. It's now for the Supreme Court to decide that issue. There is no expansion of adultery laws. That also is wrong. In fact, adultery is not at all not an offense under the new penal code. Largely, this is my initial critique of these acts. The Evidence Act, again, has not been tinkered with to a great extent, and I'm very grateful because that's one of the finest pieces of legislation ever, albeit by a colonial power. There's been rearrangement of sections and amalgamation of sections, but it's largely been untouched, except, as Justice Gupta said, with respect to electronic evidence, which was anyway being followed through judge-made law. But otherwise, the Evidence Act has remained untouched. But there has, as I said, the penal code is the one which causes most of the problems, and it is not really as revolutionary as it is made out to be, because most of the provisions exist, but at a different place in the penal code, and the ones that have been added are anyway part of other statutes, so one doesn't quite know which or the other will prevail. These are my original comments. I can.
We can open up the floor.
Yes, thank you, Rebecca. I sometimes wonder that, like you said, it's just old wine in a new bottle, and maybe instead of spending so much time and energy and just rehashing the whole thing, maybe they could have concentrated a little more on police reforms and all. And yeah, so that something more, because at the end of the day, as Justice Mukta Gupta also said, that is how you see the law and how the law is actually interpreted, how it is used on the ground, and how the citizens are going to be subjected to and are going to face these new laws and these new changes. So we can only hope that the right people are also trained and educated in the right manner so that there is lesser misuse, because even the old laws were being misused, not just by the citizens, but the reason why misuse happens is that very often the agencies that are supposed to enforce the law, they are themselves failing a bit in their duty to carry out the mandate of the law. So thank you both of you. I would now request and open the floor to everybody here. If they have any questions, they can ask both of our panelists today.
Yes, please. One question. Will the new changes be helpful to control the crime or false cases?
False cases.
Will the new changes be helpful to control the crime against the women and to control the false cases?
Whichever files a false case, will this new law help in?
Firstly, I want to break this bogey of false cases that women are accused of. I'm not saying that all cases that women file are true. But I certainly will not, as a woman, take the burden of false cases on women, because a large majority of cases are filed by the state and not by women. We never talk of false cases when a false complaint of cheating is made or the law is manipulated in other ways, but somehow women have been made to carry this burden of false cases. So I contest that. Secondly, if as an answer to your question, is this law, will it prevent misuse? I've said it's opened up more areas of contestation, so I don't see how it will prevent misuse. It has made more offenses as far as rape. The whole promise to marry thing has become another offense. So it's not going to prevent misuse. It might add to it.
My name is Gaganjot. I'm an advocate. I was curious about the provision pertaining to mandatory audiovisual recording of search and seizure procedures. So I was wondering whether, in your opinion, this would be treated as a mandatory requirement by courts, whether trials will turn on whether there has been compliance with this requirement or not, or would it be treated as something that is recommended for investigation agencies and not something that taints evidence that is recorded?
See, there are two things. Supreme Court says, if a provision is to be treated as mandatory, then the non-compliance thereof vitiates the trial, right? Now, which are those provisions which can be treated as mandatory, which affect the very existence of the offence? Now, supposing there are a series of judgments which have come in drugs matter. So, what provisions they held to be mandatory? That giving him a notice was mandatory, otherwise vitiates a trial. Because possession itself is an offence, everything incidental to possession was held to be mandatory. Now, here, when you are investigating, it is a post-event factors which are there. They are not close to the offence. They are post-event. So, to my mind, it would be that if there is a breach of it and there is an explanation rendered, then that explanation can be accepted. They cannot be held to be mandatory in the nature to say that non-compliance thereof will vitiate the trial. It's something like you have the provisions like narco analysis and polygraph was struck down, but your blood test and all were upheld. Reason being, blood test and all handwriting are not directly incriminating you, but they had the tendency to incriminate you. So, if it goes to the core of the offence, that it implicates immediately, then probably yes, it would have had been a mandatory that non-compliance would vitiate, but here investigation will be always a post-event conduct. So you are just collecting the evidence at that stage.
So if I may just, so let's say we are dealing with a situation.
Let's not take supplementaries at this point. Let's just give
Can I
chance.
just add one more thing to it? I think you must understand it can't be mandatory. Just look at the country you live in. We are not dealing with Delhi, right? There are far corners of this country where audiovisual recordings may not be possible. So you have to be realistic when we deal with these provisions. Delhi, Bombay, Calcutta centric. This is not just for citizens of for the bigger cities. It is a pan-India law. And it is just possible that none of this is available in many parts of the country, in rural India. And therefore, you have to deal with whatever evidence that they can produce. So I don't think anything will get vitiated. That's a norm that you aspire, I imagine. Although I have problems with audiovisual recordings, but that's for another day. But I don't think you can say that its violation will vitiate a trial.
Yeah, I'm Smita Gupta. If I could ask, I just want to ask a question, Rebecca. So suppose I'm a transgender person and I'm raped. Then I want to go to the police station and file a complaint. Under these new samyatas, how will the police handle it and how do I file that FIR?
Good question. I think presently they have, again, you see, if you see the definition of, if you see chapter 5, it says offenses against woman and child, right? Obviously, a trans person is neither. I don't know how 63, which is the foundational definition of rape, will apply to a trans woman. As I said, for a trans man, there's no provision. You go back to the Transgender Act, where you have, I think, section 18. What was the section? 18 subsection 4, where they define it as sexual assault, where the maximum punishment is 2 years. That is all. So that is why I said, while they have expanded the definition of gender, in my preliminary reading of these sections, I don't think they have included trans persons as persons who can benefit from these provisions.
Maybe when they were trying to make it more gender neutral, they should
I also feel sometimes you have a tendency of just throwing things because, it's fashionable to talk of, because our language has changed. But unless you parallelly make provisions to take care of those vulnerable sections of society, specifically dealing with their vulnerabilities, there's not much sense in having a definition which says that it includes man, woman, and trans persons. I don't see that parallel. I don't see parallel reliefs being given to those persons in these provisions, unless if you, of course, you deal with gender neutral. Deal with generic sections like cheating, or of course, then anyone can access those. Anyone can access those laws. But with particular reference to sexual offences, I don't think they have been treated fairly.
So, Rebecca, I just wanted a clarification. It means that the perpetrators, there it is gender neutral.
No.
The victim is always
for rape.
For rape.
No, it's a man.
Okay.
It says a man is said to commit rape.
Okay.
Only with respect to voyeurism and stalking.
That is gender. There was a gentleman.
Hi, my name is Shivam Gupta. My question is with respect to how the new legislation has sort of identified the concept of nyay, that is justice. Yet again, as Justice Mukta Gupta mentioned regarding the imprisonment term that is there in existence, it has been made to a certain definite, and the discretion of the court has sort of been eliminated. And justice as its own concept does not limit itself just to attain the ends. It is about the means and how it is being achieved. And similarly, as it has been mentioned that certain other offences and certain other means and methods that were there in earlier CRPC have been totally annihilated by the new legislation. So as you being the major stakeholders of this particular field, I would like to ask you, what is your concept regarding attaining justice, considering that the new legislation totally goes against the basic values that India in itself historically always incorporated about focusing on means? Means being the justice method and ends being what is achieved out of that means.
Gosh, we'll need another session on that. That's another debate.
Because means there are so many stakeholders which get into the means. And that after each one of them contributes to these means, this is the end result. As I said, legislation is one thing, interpretation by the court is something, implementation by the executive and anything. Then in implementation and even in interpretation, there is so many different means to be applied. So sentencing is only one part of it. The sentencing is not the end of it. It's never the end of justice. A compromise, an ADR can always be an end of justice. So there is this means employed will be, it cannot be put in a straitjacket, it will have to be case to case basis.
But Justice Gupta, having sat on the bench for so long, I think she made a very, very valuable point that discretion is central to justice. You know, when you take away discretion from courts to sentence to a lesser imprisonment, you know, I'm not a fan of over sentencing. I think we everything becomes life, death, remainder of your life. You know, at the end of the day, if you say all of these laws are reformative in nature and that's the ultimate goal, then where is that? And I think she made a very valuable point when she said that when you have up to a certain thing, you look into many mitigating circumstances and come at what at that time you believe is a just and fair sentence. Whereas now that discretion is gone, and therefore you have no choice but to punish the maximum, the minimum actually, because there is no maximum or minimum. That is the sentence.
I mean, I'll tell you, even now, I get queries. This has happened. And we feel that it will be very unfair to give the sentence of 20. Just tell me the reasons how I should give a sentence which is lesser.
Actually, judges grapple with it all the time, because, you know, you're sending somebody away for 20 years, it's not easy. It's very, very difficult.
Imagine a child who was just 20 at that age.
Yeah.
20 years means 40 years of his 40 years gone.
By the time he comes out.
By the time comes out. So if you leave that child at 30, you still feel, look, he's got a life. He can still settle. But 40 is something ruining totally.
It's a long period.
Now, supposing, I'll give you an example. Today, digital rape is a rape. Now, you don't get any medical evidence, even for a minor, that a rape of this kind has been committed. You have no means to discard a statement that you don't rely upon it. At the same time, you feel there are overtones of a landlord-tenant dispute, and the accused is 20-year-old boy. Now, what will you do? You will have to sustain the conviction if you are my or any judge's position. But for a 20-year-old boy, would your conscience, for an act of fingering, permit him to give him 20 years of sentence? Will it not be too disproportionate? You would like to give it where a brutal rape is done.
No, also this can be misused, which is already there.
This is exactly, you see overtones of
young couples.
Young couples.
In POXO, that's the biggest problem, because you have lowered the age of, you've raised the age of consent and you've lowered the age of juvenility. And actually, if you ask judges who sit and try POXO cases, this is what they struggle with. They know, because I was told by a judge that the boy came to her and said, I didn't know she was less than this. I mean, I thought she was 18. Do I have to take a birth certificate from her before I enter into a relationship? The girl is saying, I went with him willingly. And yet the parents are saying, no, throw him in. It's a very, very difficult task when you don't give any discretion to judges.
And the girl comes to you with a fait accompli that she's got a child. But you still have to say that the law says it's an offense committed. You see that minor girl's life, you see the minor, that unborn child's life in front of you, and you see that 20-year-old boy standing in front of you. You see that because of this act you'll be spoiling 3 lives, and then you try devise means to find out, insert something that this person is false, this person is false, let them go and leave. You know, it is said, more stringent the provision, the more tendency of the judges to leave it. So you see, initially, what used to happen, for a 1 gram drug also, the sentence was minimum 10 years,
10 years.
or extend to 20 years. Now anybody would feel, yaar, to ye to zara sa paise ke liye, poor person who had no means was utilized to sell these 1 gram, 2 gram, 5 gram. So what would end, and now when it comes to you to an appeal, the person has already spent 6, 7 years. Now what to do? It's really injustice that this person for 1 gram is in custody for 7 years. Then you try, dig into the file and find out and acquit the person. There is something called, you know, that inherent thinking that you are not doing justice because you are bound by the law. So you tend to then break the law somehow. In fact, one of my senior colleagues said, we can't break the law but bend the law to such an extent that it gives justice. So often we bend that law to give justice.
But may I say something? I have worked with drug prisoners in Tihar jail, and the tragedy is that even when you have bent the law to give them a chance, the society is organized in a particular manner that the chance doesn't come, they come right back. We have the same people coming back to the prison because they have no other alternative.
No, there are 2-3 reasons of it. Once he is convicted in a drug case, police finds him an easy target. So they implicate him or her again and again. Second, with this kind of an abuse, they don't get an alternative employment or a settled life. When they go back to their peer, "Arey, ye to charsi hai, ye karta hai," people just make him outcast. They don't absorb that person into the society. So they will absorb a rapist uncle into the society, but they will not absorb a person who is into drugs. And not understand that probably when he got into it, it was initially addiction, then theft, and then to get money for that drug, he got into that circle.
Vicious circle.
This is that vicious circle. And we don't have good rehabilitation means to me.
Yeah, that is the main.
I mean, we've been struggling with
80%.
Yes, I think I've been on the Juvenile Justice Committee 14 years, and before that standing counsel. One organization which was doing commendable job in this was SPYM. Otherwise, we don't get anybody the way they reform the child. They rehabilitate the child properly because it's not a cure. It's a complete rehabilitation. Even after complete rehabilitation, there are cases that they again come into this. Because if you don't take away from that peer, when they go back to the same peer group, the same peer pressures are there. So in some of the cases, we got them employment and we said, let them go to a different hostel. They will not come back to their peers for a long time. Because even if it's not doing it, family, neighbors, brothers, sisters, everybody will be able to.
You said a lot about that these laws definitely lack a lot, in the sense, as far as I can understand, that if अगर 302 को नहीं कहा जाएगा, 420 को अगर हम 420 छोड़ देंगे तो हमारी तो काफ़ी हद तक तो लैंग्वेज भी बदल जाएगी क्रिमिनल की, बिकॉज 420 ही तो हम ऐसे यूज़ करते हैं जैसे कुछ, हाँ, यस, और of course I can understand
anybody cheated, ये तो 420 है.
Exactly, I can understand the predicament of the judges who for some cases, for the time being, for some cases have to shift to this, and then for some cases have to. Now, what I want to know is there no way to let the government know that these are the problems which can be easily resolved? Can't we keep the format of the same?
No, see, it's a legislature, it's an enactment which has been passed.
Yes.
by the legislature.
They can always be,
Assented
I
by
mean,
the
I
No,
want
no,
to
it's got a
If there are
presidential
channels.
assent. Now, only challenge to this can be if there is viries, constitutional viries are there. On the ground of practical difficulties, you can't challenge a legislature. You can only challenge if it is contrary to the constitution.
I believe
So
before they are
these are, and that's
passed,
a very limited ground.
yes, I
It's the
believe,
same
Sorry.
provisions, but slight tweaking in the language, making it loose, will cause lot of problems. But practical difficulty can never be a ground for
Challenge.
I believe, ma'am, once the legislation, the bill is introduced and then of course
It is being
it
enacted.
is enacted. Yes, now it's been
Only
enacted.
thing
as
is,
it
we are waiting for the day it will come into force, that they will notify a day and it will be into force.
So no channels, after all amendments are there.
No, I
No
mean,
challenge.
as the act, as we deal with it, of course there will be challenges, and as you know, law is never static. I mean, there can always
No,
be.
that I understand, ma'am. But this thing, what I'm trying to say is, at some point of time, there must have been channels because the practicing lawyers are the one who can immediately see, who can immediately foresee the problems that are coming.
So can I just tell you, when this was first notified, National Law University Delhi was a nodal agency, and there were 5 or 6 people in that committee. They sent questionnaires. This was during COVID. They sent questionnaires on different sections of the Penal Code, CRPC, as well as the Evidence Act, to all practicing lawyers, to NGO groups, etc. Many of us formed groups and responded. In fact, mine is a big volume lying in my office. Responded to what we believe what positive changes what should be deleted, what should be retained, what should be added. I don't see any of that
Exactly.
in this. So there was an interface with ordinary people, with practitioners, but they have decided
Somehow
to pick
not
up.
incorporated.
Yes. I mean,
That's
maybe
sad,
from their
very
point
sad.
of view, what we wrote was rubbish. I don't know. They may have their own their own ideas about what we wrote.
Okay.
But the point is, there was an interface. It may not have been robust enough, but now this has come. We'll have to learn to live with it.
Exactly.
First we'll have to
You see, again, as I started, there's nothing wrong if some law is being relooked. After all, these were all century-old laws. Some of it was archaic, some of it needed change. So I don't think one can fundamentally oppose the need to amend a particular statute or overhaul it. In 1973, Justice Gupta will bear with me, the Criminal Procedure Code was completely rehauled, and a new Criminal Procedure Code was brought. And again, sections, the placement of sections went all over the place, but people got used to it. So there's nothing wrong in amendment per se. I think our critique is that if you had to carry out this exercise, there should have been a meaningful exercise that you carried on. If you're retaining all provisions, then you could have kept it the way it was. And the few provisions that you've added are so loose in their definition that it could lead to huge amounts of misuse.
yeah.
I'm a student of political science. Hello, good evening everyone. I'm a student of political science honors. So the first question which arises to my mind after this discussion is that why were these amendments actually necessary, and are they in tune with today's changing times? Also, how are these going to affect our rights and liberties? And the second question is that there are various plus points and minuses about the amendments, like the addition of transgender rights. Transgender laws have been added, which is a great plus point. But according to my thinking and my, what I could pick up from this discussion is that isn't it just a facade to pacify the communities and not actually grant the real rights needed for the transgender communities?
So I think most of this has been answered, because I think what were the reason, ma'am also told you, that because you can't have laws which are stagnant, and laws have to change with time, So there's nothing wrong in the exercise that they have done per se. But the fact is that maybe they should have applied their mind a little more and seen, I'm being kind, to see that, if you're taking on such a big exercise and you're absolutely revamping everything, there's no, and you've not done it for so long, do it properly. If you have asked for advice, this is my take on it. If you have asked for advice and you've had a consultative process with stakeholders, with practitioners, with NGOs and all, don't just take the advice for the heck of taking to show that maybe, yes, this thing. Then please have a proper discussion, go into the issue, because ultimately everybody, I'm not blaming the people who've done it or anything. Things like this come to haunt everybody. Today, someone may be in a position where they can use it or misuse it. Tomorrow, they may be in a position where they will be at the receiving end. So, to ensure that any law is, applies, can be applied with an even hand, and is, has the least potential of misuse, that should be the attempt. Yes, please.
I'm Seema, I'm from Wisconsin. Looking at the chapter on crimes against women and children, and the kind of, more drastic punishments that are being advocated. And at the same time, if you look at the crime data, in 90% of the rape cases, the victim is known, the perpetrator is known to the victim very often. And it's been, for decades, it's been close to 90% in terms of the cases that are lodged. What are the social implications then of having this kind of stringent punishment, for a lifetime, for the breach of trust, if one may say so? What does it, mean in a society in which women's honor becomes a cause not just for, them being victimized if they face sexual offenses, ab to tumhari zindagi khatam ho gayi is the kind of, rhetoric that is there. How does the woman survivor come out of it? There are so many social implications of what these new laws are doing in terms of making it, the punishment, so much more.
I'll tell you, when this first time amendment came, that there should be enhanced punishment of 20 years or remainder of life, I told the then minister, we were presenting a report on another aspect. I said, what you've done is wrong. The more stringent punishment, the tendency when the court finds it's a borderline case, to give the benefit of doubt to the court accused. Secondly, there is nothing for rehabilitation of that woman except for compensation. Thirdly, I told them that your rape data is very, very incorrect and cannot be relied upon for the reason 30% cases are promise to marriage cases, rape. When the marriage doesn't take place, the FIR be registered. After the marriage is taken place, then they say quash it, as if this law is a tamasha. Then, so it's an extra means of extortion, right? Then 30% cases are those which are runaway, couple being 16 to 18, the adolescent one. They will say, हम तो साथ रहेंगे, दोनों को जेल में डाल दो, माँ बाप के पास नहीं जाएंगे. और आप खड़े उस टाइम पे देख रहे होते हो कि क्या करें इसको, कैसे बचाएं इन सबको. छोटे छोटे बच्चे हैं, we have to take care of it. Now, if there are 100 cases, 60 are this, and 20% are false implication because of the landlord disputes, financial dispute, you are left with 20% of the right cases, and the actual 80% on whom rape takes place, they don't even come and report. That's the problem. They are unreported.
also this thing about,
So
having-
what you are doing is actually not helping the system. The answer was, at least the fire will be doused at the moment. That was a simple answer.
No, also
Let it happen.
stringent punishment has not worked as a deterrent.
Never.
Because
Exactly.
rapes have not stopped. In fact, people have become, in some way, you hear now more horrific ways
And killing of the
Yeah.
victim.
No, but you see, then they kill even more because if she survives, then she can identify you. So, then it's probably better if they do something like this than to do away with that person.
Yeah, Justice Gupta, can I ask the way Madam is trying about rape cases? In most of the European world, sex workers are a professional. They pay tax also. In India, it's a very strict prostitution. So can we amend this Prostitution Act also?
See, there is, if a major does prostitution voluntarily, it is not an offense in India. Person who traffics is an offender. Person who traffics a minor is an offender. If you put that person into trafficking and exploitation is an offender. Personally, anybody can, for their own wish, do whatever they want. Right? It is not given a legal color, but it is not even an offense. The problem lies in trafficking or prostitution is when minors are misused, abused, and for that purpose. And what happens is, even if you do help them, by the time you rescue them, their mindset is such they feel that this is the end of life for them, and please send us to that, we can live our life over there, because the acceptability into the homes,
Yes.
the acceptability into the society is not there. In fact, I had done number of rescue operations got done, and the major challenge was not recovery of the girls. The major challenge was their rehabilitation and a meaningful rehabilitation. So, even with the parents, so what formula I took was, yes, I gave them so much of meaningful employment that the entire family started accepting me. One of them was that got in touch with Amul, gave them training, and then they would open a kiosk near the house of the. You can't, a victim, you can't keep homes and keep them in a building like this for years. So for anybody to rehabilitate, the home is a natural environment. But there the families were not ready to take. But when she was earning somewhere around 10,000, 12,000, then they were very happy. They all accepted. So one of the means to see that there is no sexual exploitation and the victim is rehabilitated properly is make her an empowered and a financially independent woman, for which we don't work. There will be hardly any NGOs working into this sector. I'm not saying any, this is hardly some.
No, but she's right. So, yeah, I don't think so. No, there are exceptions for sure. But you see, rehabilitation also involves a lot of having the wherewithal. A lot of agencies do a lot of good work, but they don't have the wherewithal.
They don't have the
to
wherewithal.
take it then right to the
And it may or may not be successful. That risk is also there.
That risk is there.
And also the earnings come down.
Come down.
They don't
Yeah.
want to, then it becomes difficult to rehab.
So I would like to thank both our speakers and the audience, because I think this has been a very, very educative session for all of us. And I think going forward, I can see that both Justice Gupta and Rebecca are going to be very busy because first learning it, then having to teach it to people like us, and then when the challenges come to court, which I'm sure they will, and as they should, and take this forward. And I hope that the courts will, find it to be able to draw a balance and see that, some corrections are made which will reduce the misuse of this law. With this, I thank you all, especially our speakers and all our friends here, and request you to please join us for a cup of tea outside. Thank you very much.
We would also like to thank everybody from the Justice Sunanda Bandari Foundation and the Guild of Service for the tremendous secretarial and coordination effort that has been, with a special mention of Ahmed and Renu. Please join us for a cup of tea at the terrace pergola. Justice Gupta, please join us for tea.